It's a sunny morning here. It's 29 degrees in the Federal Capital Territory in Abuja. I'm Maupe Ogun Yusuf. Good morning and welcome to Sunrise Daily, your daily dose of sunshine.
Well, you wanted a daily dose of sunshine and there you got it. In Lagos, the temperature is about 29 degrees and it feels like 36 already. And God knows what it's going to rise to. Today is March 25, 2025. It's a Tuesday morning. I'm Aya Makinde, and I say welcome to the show.
Indeed, Ayo. Well, we're taking you to one of our well-kept secrets here. It's around the Federal Capital Territory. We like to claim it for our own, but sadly, it's a Niger state. And I think that this is about maybe the last opportunity you will have, the last period you will have to see it before the rainy season. And before, with the holidays in the offing, children writing their second term exams, and also people preparing for the Ramadan break, preparing for Salah, as they say, and also preparing for Easter, which is coming much later. You still have, just about the right amount of time to plan to see the Gurara Falls. Yes, it is majestic in the rainy season, but then it's also impossible to see. It is impossible for visitors to fully explore because all of this patch you're seeing becomes very flooded with rain waters. But about now, in the dry season, as the rains begin to come in very gently, it's a wonderful opportunity to explore this God-given resource in Niger State, just on the fringes of the Federal Capital Territory, somewhere in the border between Niger and Abuja. The Gurara Waterfalls. Ayo, is it an offer that you'll be taking up just before the floodwaters take over?
To be honest with you, Maupe, every place we have shown in from Nigeria, on this program, is a sight for sore eyes. You just want to give it a thought. Now, to anyone looking at it, there's some rough road there, here and there. I tell you, even Grand Canyon would be very jealous of Gurara Waterfalls, if you ask me, because of its naturalness, because of its beauty, and because it's a place you can escape to. Please, I don't know, Malkwe, if you'll be able to use your Wi-Fi or your mobile device, mobile internet when you go there, because it's, distant from civilization, some would say. But the truth is, it's a good getaway place. It's a place you can go to you want to clear your head, literally. This is the place. The majesty of where that word is so apt for what you have said. So please, take in the beauty of Nigeria straight from Gurara Waterfalls in Niger State, neighboring Abuja.
Well, while you make your plans for the Easter and the Salah break, we have to come back down to earth. Something happened yesterday which started as a rumor of sorts, but clearly it has now gone beyond the realm of rumor and has now been confirmed. Yesterday, INEC received a petition from some members of Kogi Central Senatorial District, saying that they have signatures, about 250,000, seeking to recall Senator Natasha Akpoti-Uduaghan. You're very aware of the controversy that has since brewed since Senator Natasha Akpoti alleged that Senate President Godswill Akpabio, sexually harassed her. And this will be the latest in the long list of things that we have seen since that announcement or since that, claim came to light. So yesterday, we saw a group of people led by a young woman, interestingly, making their request to INEC and INEC receiving that petition on their behalf. So listen to what she had to say.
We're here to submit the petition against the senator representing Kogi Central Senatorial District in the National Assembly, the Senate arm, Senator Natasha Akpoti-Uduaghan. We have come to submit a petition of loss of confidence. The entire people of Kogi Central have lost confidence in her because of her gross misconduct in the Senate that led us to a 6-month suspension where Kogi Central will not be represented at the National Assembly, the Senate arm. So we have come to recall her back so that we can have a representative in the Senate, because as a people, we cannot afford not to have a representative in the Senate arm for another 1 year. So we are here to tell INEC to please follow the constitutional process for our recall so that our recall process can begin. That's why we're here. Submitted our petition. It's been received. All other documents have been received. This is the acknowledgement copy of the petition. We all know the INEC rules. You cannot submit a petition without having to go and get signatures of registered voters. And that's why we're now saying, as a people, we are recalling her back from the Senate, because we have gotten what it takes to recall her back from the Senate.
Like how many?
Well, that is the representative of concerned Kogi youths you heard. Well, joining us this morning to take a look at this particular matter, we have with us Mr. Victor Giwa. Mr. Giwa, it's good to see you. Good morning and welcome to the program.
Yeah, thank you for having me.
So this is no longer in the realm of speculation, because we had heard initially that indeed some recall process had started, but it was being done under the guise of a, what was that now? What's
Empowerment.
Empowerment. But it was controversial. It was seen that, there was some alert being raised on this. But clearly, it does appear that this is what we're now seeing. This is now the result of what has transpired. Do you want to shed a little more light on how we got here?
Yeah, thank you very much. Thanks so much for having me, Omakwe. Now, firstly, it has been in the news, like you said, about the recall. If you heard the young lady that spoke, she said she's from Consigned Kogi Youth and Women. I don't know what that is. I am the lawyer. I'm one of the lawyers to Natasha, and we've been interrogating the process. We know what the recall process is under the Constitution, Section 69, and the INEC guidelines. She said she's representing Kogi Youths and Women. I don't know what that is. The persons who have the legal right to recall is our constituency. In this case, Kogi Central. She has not been able to tell us if she belongs to the 5 local governments that constitute Kogi Central. Now, she has not told us who are those people who voted, are they the registered voters. In the process of recall under the INEC rules and regulation, the names of the person who should sign for the petition should be polling unit by polling unit. Question is, when were those persons, where were those signatures collected out of the over 800 polling units, within the over 1,200 polling units within the 5 local governments that made up Kogi Central? And we've seen social media reports, which we are looking at to see where we noticed and we saw some group of persons inside one room trying to write names, and I think that is what they have just done and brought up to say that they have gotten 250,000 names. We have personally written to the chairman of INEC complaining of allegation of forgery against the said petition. Now, INEC has the constitutional right under Section 69 to verify the signatures in that petition. However, as person who is concerned about the rumor and the stories connecting the signature that they have received, as a citizen, as somebody who is concerned about the process shouldn't be fraudulent. When you see people sitting somewhere, writing names, putting signatures, that is a clear case of forgery. So it is duty for me to notify INEC, and so we'll take it further. We are going to, by tomorrow, we will send the petition to the Commissioner of Police, Kogi State, to verify, to investigate how those, because that is a different, because the issue of forgery is a crime, and it is the duty of the police to investigate crime. While INEC has their constitutional duty to verify those petitions as provided under Section 69. So if you look at it, it looks as if there is a script somewhere, and like I said in one of these programs, it's a melodrama. And I want to see how it plays out. But one thing we are sure of, that this process cannot be completed.
Let us, take a look at, because we did hear, and these are some of the videos that made the round, some amateur videos that made the round on, social media, alleging that some empowerment process had started under the guise of, the recall process had started under the guise of empowerment. But it did appear that some of the will I say, the citizens were aware that this was what was going on, and then you could hear their voices in the background saying things like they were speaking their own traditional language. I didn't understand what was being said, but it did appear that there were concerns that this was what was happening under the guise. If indeed there is a recall process, aren't the citizens supposed to be clearly aware of what is transpiring? Are they supposed to be, because you have talked about forgery, but if indeed it happens that, people were being given empowerment and they were asked to sign in a particular place and it is indeed their signatures, but they were not aware of what it was that they were signing for, doesn't that make the process null and void?
That is a very good question, and that is one of the concerns we have. Now, the first part is that, like you said, the process of recall must be a process that the registered voters are aware and conscious that they are going to recall their member. It must not be in any form of deceit. They must be aware, they must be conscious, they must be noticed to that effect, and they must have volunteered themselves to go through the process. We've not heard of any town hall meetings that were held that the persons, the constituents, the unit said, we have to recall these persons. All we just had was that, some people were in the queue. We were seeing videos of people standing in the queue. Thereafter, they were now saying that, they told us we're coming there for an empowerment. And what we now got to, they told us when we pick up, we put our voter's name and all of that, and we signed. Like you said, let us assume that was what happened, that they were brought into a particular place for the purpose of empowerment, and they now discovered that it was for recall. That itself is deceit. But you see, it is one of these things. They just brought that process for you to see that, the recall process has started. We need to see it in every unit. Under the INEC guidelines, each of those names of the registered voters must be from polling unit to polling unit.
It cannot be done in
one... So it cannot just be done in one hall and people... No. The names must be arranged polling unit to polling unit because votes are done in polling units.
It's a very interesting scenario, but this is the situation now. INEC has now received the petition. What should happen next?
Good question. Before then, there was a court. We went to court in Kogi State, in the State High Court, where we got an ex parte order restraining INEC from receiving such petition. However, yesterday we got wind of the information that whether they went to court, to set aside that order. But the first part we need to understand was that INEC received that petition while the court order was still subsisting. INEC was served with the court order, with ex parte order, restraining them from receiving the petition. That is, by the way. The second part is that there is a subsisting case in court, which INEC is a party.
What was the case?
The case of suing INEC, restraining, which we got an order restraining INEC from receiving the petition, since the constituents against INEC, not Natasha now. Some of the members, the registered members of that constituency say, no, don't receive this petition. We've not agreed to recall her. And that is the case that is subsisting, which INEC is the party. So the point I'm making, therefore, is that when there's a case in court, INEC cannot take any step until that case is determined. Because when a case is instituted, parties are expected by law to maintain status quo. So having received the petition, INEC cannot go ahead to start acting on it until the case in court is dealt with.
Well, Mr. Victor Giwa, we certainly will keep tabs with you, around this development, because we do know that this is a developing story. In the meantime, we also know that Senator Natasha has, issued a statement saying that she would not be forced to apologize, and that any, conversation happening around or any statement anyone sees, purporting that she has apologized should be ignored.
Disregarded, yes.
Yes. So I just want to know, do we have any further updates with what is happening in the Senate with regards to her petition?
Well, from the information we are getting, the Senate seems right now to be thinking about, okay, let us really look at that allegation. Because our position has been that, look, there is an allegation against the Senate president. She has a right to be heard. and that the Senate president should step aside and allow investigation to take place. Whether or not the stories are correct, the committee will look at it and come out with a report. But you cannot be presiding over a process that you yourself have been alleged. And that is the point we are making, that it must be dispassionate, it must be impartial, and she must be given a fair process. And that is what we have been saying. So we are looking up to the Senate, to look at the issue, bring all the parties, interview them, do your investigation, and come out with a result.
So the Senate has not yet given word on when the petition will be heard?
Yeah, the Senate, we've not heard anything from the Senate right now. However, we're also in court too. Of course, there was a court order restraining the Senate Committee on Ethics, Privilege, and Public Petition from going ahead with taking any measures on the issue of our actions in the Senate. But the Senate went ahead and suspended her. That's part of that subject matter is still before the Federal High Court, before Justice Oguta. And so there are a lot of potpourri of issues. I don't know how the Senate want to go around it, but it is left for them to handle.
When has the case been slated to be heard?
Yeah, I think the case has been adjourned to 23rd of April.
23rd of April?
Yeah, by next month, yeah.
Okay. It's interesting that Kogi has been, because the only time that we have also heard of a recall, even though we know that it is in the Constitution, the only time that we have heard of a recall process too was about a senator in Kogi State. It is interesting that it tends to, be the state or the area that always wants to test this area
of law.
Yes, and I find it quite interesting. How do you think that this process will eventually play out from your own projections?
As much as I'm concerned, there have not been any sources in terms of a member or a senator recall in our history.
Yes, and I remember very clearly there was something that Senator Ike Ekweremadu did say at that time when I think it was Senator Dino Melai was involved in that particular situation. He said, and a lot of Nigerians, took him to the cleaners when he said what he said, that the law has been structured in such a way that it is almost impossible to recall a senator. And perhaps this case actually makes it clear as to why that was done. Because after a senator has been elected, it should be a bit difficult. People must really be very clear as to what they really want. And it shouldn't just be anybody being able to instigate this. And we know just how powerful governors too can be in matters like this. So from what you see, do you think that hurdle will remain for members of Kogi Central Senatorial District?
The truth of the matter is there is no way the recall process can go through except it is done fraudulently. And like that was Senator Ekweremadu that you were quoting, a former Deputy Senate President.
You remember, right?
Yes, of course I remember. And the reason is this. As a matter of fact, if you look at Section 69, it looks a bit easier. But you need to now go and look at INEC guidelines and regulation about recall. It is 15 stages, part of which is you have to take those signatories, INEC have to verify, you have to conduct a referendum. You have to appoint verification officers to go to each of the polling units. You have to collate them, send it to the REC. It is a tortuous process. So it is not something like he said in his words. It's something that is visually impossible to be done. If it has to be done, it has to be done fraudulently, like what they are doing, going somewhere, putting votes together, and coming up to say, that you are going to have that vote. It is going to be very, very impossible. And the reason is this. It is because when you vote it is tenured. When you vote for your senator and for a term of 4 years, it is expected that if you know that you have lost confidence in him or her, you should allow his tenure to end, so that next time you don't vote him again because you have a period of 4 terms. So they don't expect you that you should now start looking for ways. And in this case, like you mentioned, the lady that led that protest, she's the Senior Special Assistant to the Governor of Kogi State on Women and Youth. So the question you will now ask yourself is, you will now see that it is government-sponsored recall.
The
Charity Ijese Omole, she is currently the Senior Special Assistant to the Governor of Kogi State on Youth and Women Affairs. So you just made allusion to, you can see that it is more or less government sponsoring this process, not the constituent, and that fundamentally has faulted the process, because the process of recall must be such that is initiated from the constituent. But in this case, like we can see the handwriting on the wall. It's the governor that is trying to do whatever they claim they are doing.
Let me bring in my colleague Ayo, because I understand he also wants to ask a question. Ayo.
Well, first of all, Mr. Giwa, is she senior special assistant or special advisor? Because we hear that someone was indicating that maybe she's even been promoted, so she wants to validate her promotion. I don't know if you can confirm that.
Yes, she was special assistant. Then she was promoted about a week ago, and so maybe she wants to justify her promotion, and that's why she's doing. I'm even querying the fact that whether she's even from the constituent of she's from Kogi Central. We are still querying that part if she's actually from Kogi Central. But what I can establish is that she was promoted from SA to SSA just about a week or two ago.
Now, Mr. Giwa, there is an issue that started this whole conversation before the indictments of the president of the Senate came up. The fact that the rules of the Senate were the rules of the Senate, the fact that so many people, in the Senate discussed the issue, and it just wouldn't go anywhere. As far as the Senate is concerned, they have rules that the distinguished senator was unfortunately unable to abide by. It was discussed on the floor of the Senate. Everyone saw that conversation. And the fact that even the ethics committee to which the Senate sent the report said, look, this is dead on arrival because he hadn't gone through it hadn't gone through the normal route. As a lawyer, how do you perceive that?
Well, firstly, you brought a very good issue. Now, the first point we need to get, and a lot of people have misinterpreted and misunderstood the issues. Firstly, what Senator Natasha was saying is this, that on getting into the floor of the Senate, her seat was changed. Now, she is not contending and contesting the power of the Senate President to allocate seats, because that is contained in Order 2 of the Standing Rules of the Senate. That is not in question. That is a given. What she was saying and what she was insisting on was that her seat was changed without notice. And to see how important the issue of seats is in the Senate, it was contained in their standing rules that you cannot speak except from your seat. Now, when such thing as important as a seat of a senator, that is not a shrine, that is not a playground. The floor of the Senate, that a senator's seat has been changed. It is incumbent, it is inherent that the Senate President, via the clerk, communicates to the affected senator about the change in the seat. So what she was saying was that I was not informed about my change of seat. I had no notice about that my seat was changed. And she was raising that point on that point of order. So the proper thing and the elementary thing and the fundamental thing to have done is for the Senate President to have had her, then rule her out of order and say, oh, your seat was changed, we gave you notice. Maybe it was, if you watched in the incident of Senator Saraki, when in the 8th Senate, or the 7th Senate, when Senator Saraki was Senate President, the same incident happened. And you will hear Senator Saraki telling Senator Akpabio, I informed the clerk to inform you. Because the proper thing to have done is that when the seat is changed, which the Senate President has the power to change, the clerk now informs the affected senator. So in this case, it was not done. And she was contesting why that change was done without prior notice to her. So it is not that she's challenging the Senate President, you don't have right to change my seat. No. And we felt that, and it is strongly believed, that she has a right to be heard. Then you now explain the reason why, or you rule her out of order. But that was not done. And that was where the malice, and I was how she said, oh, this is malicious because you have made some sexual gestures to me, and I refused. Maybe that is why this incident is happening. And so that is exactly what happened. Now, on the petition, the Senate committee looked at the petition and said, based on the rules, a senator should not sign a petition. Now, they misinterpret again that section. The idea is that a senator representing a constituency should not be the one to sign a petition coming from the constituency, because you are just a representative. It does not consider the issue of when the senator herself or himself is having an allegation against a fellow member of the Senate in the House. So if I have a personal grounds as a senator to my fellow senators, I don't expect my constituency to sign the petition of my allegation against a fellow member. So that section they read, under which they said a petition was dead on arrival, was a contemplation that for you to present a petition, the petition must come from your constituent. And that is to talk about your issue, about projects, about opinions, about anything coming from your constituency. It is expected that they sign and not you sign. But in a case where you have an allegation against a member of the Senate, it is the petitioner, which is in this case the senator herself, that has the right to sign that petition. And that is where they got it wrong, and that was how they declared wrongly that the petition was dead on arrival.
So you're saying, Mr. Giwa, that a committee made up of ranking senators and a number of other younger ones, which was a decision that was deliberated on by all 109 or 100 and whatever number of senators that sat to ratify the decision of the committee, you're saying that they are wrong. Is that what you're saying?
No, they're not just wrong, they're totally wrong.
Okay.
Because the same committee adopted the resolution, the same Senate adopted the resolution of the Senate committee when there was a court order served on them. I expected that when the resolution of the Senate Committee on Ethics, Privilege, and Public Committee was presented to the Senate, to the floor of the Senate, they should have said, oh no, hold on, we have a court order, let's go set aside the court order, just like they have done. Then come back and discuss. Why the hurry? So the same set of people, led even by some lawyers, the Senate President himself is a lawyer, the Majority Leader is a lawyer, the Chairman of the Senate Committee, he seemed to be a lawyer, and they did what they did. I just feel that they did what they did out of malice.
So, Mwankwe asked you the question the other time about the recall process. It would seem like from how difficult it has been since this republic began to recall any legislator, it would seem like it was designed to never be able to happen. Make the process complex so that the act itself is unable, the constituents are unable to get it through. Now, for you, as a Nigerian, the issues we're discussing, and I really wish you could speak not as a lawyer to the distinguished senator, the issues here, are they governance related? Are they democracy issues, or are they just sheer political issues?
Good question, and I'm going to remove my cap of being a lawyer and talk as a citizen. Now, let's just look at the issue calmly. First of all, she was complaining about change of her seat. Fortunately, Senator Akpabio has done the same before in the 7th Senate, or 8th Senate, if I'm not mistaken. Now, if that was the only issue you had against a senator, you asked her to apologize. She was in court. And you are aware that you cannot suspend a senator for more than 14 days, looking at the case laws, which they are now part of our laws. You suspended her for 6 months. The next thing you are doing is recall. Now, if you look at section 69 that talks about recall, they said you can only recall a member of the Senate or the House of Representatives when there is a loss of confidence, on the allegation of loss of confidence. That tells you that you can only recall a member of the House of Representatives or a Senate when that particular member is seen not to be performing. You don't say, oh, she was suspended, so the reason why you are recalling her She was suspended. No, 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 no. There was something that she was, you have not said she did not perform. As a matter of fact, Senator Natasha is saying that you have stopped me from performing my duty. I want to perform my duty. And the Senate President, because of the malice, he has stopped me from taking part in a lot of international activities of the Senate. He has not given me certain, he has withdrawn certain privileges and rights I have as a senator. And these are part of our complaint. The next thing we are saying is a process of recall. To that extent, I believe very strongly that it is politically motivated. It is not done by the constituent. It is not genuine. We have not seen a town hall where the issues were discussed, where somebody moderated to come to that fact that, yes, she has not done well. So the question is not that she has not done well. The question is not that she's not giving us a legal representation. The question is, oh, she was suspended. We cannot afford to have our senator suspended for 6 months, as if she was the one that suspended herself. I felt that those same persons who are talking about recall should have marched to the National Assembly and tell the Senate President, please, 6 months is too much. Let it be 1 month. But no, we are talking about recall. So the contemplation of recall under Section 69 is not because somebody was suspended. It's when you have adjudged somebody, is a member of the National Assembly, to have not performed very well. That is what we call loss of confidence in the way and manner you have given us representation, and not for when you have been punished by your own members.
All right, we'll take a short break now, Mr. Giwa. When we return, we'll also explore, because there was a conversation yesterday around whether or not democracy is thriving in Nigeria 26 years after. We'll take a short break now, and we'll return.
Works. If they do otherwise, of course, it will be failure. So, in that case, I would say it falters, it gets up, is work in progress. And I believe that we should not lose sight of the fact that democracy for now in Nigeria is the best system of government that we can have. And it is our responsibility as players to walk the walk and walk the talk and ensure that it works in Nigeria and in Africa.
Okay. When I was being impeached, the president sent people to come and intervene on my behalf. Ken Namani came begging House people not to impeach me. Today, the president impeaches the person. So that is the thing. Even when I was impeached, President Obasanjo called me and said, "Are you okay? Are you safe?" When I go back from the court, when court eventually declared me under Nduba, President Yar'Adua called my phone in London and said, "Congrats." I said, "President, I can't come back because, if I come back, these people," he said, "Tell me the flight in which you're coming back." And I told him, when I came the first time, military people came to receive me at the airport. I couldn't believe it. I took me straight to him. Now the president will ask me not to come back here again. So it's failed. Let's not talk about it. Let's talk about how you are going to do it. It's collapsing.
Well, those were excerpts from a conversation that transpired yesterday at a colloquium in honor of Right Honorable Emeka Ihedioha as he clocked 60. The question was, is democracy failing in Africa? And clearly you could see that the respondents had different takes on it. So we are going to, dovetail this conversation into the implications for democracy. Because if there's anywhere where the one institution that is considered a bastion of democracy, it is the legislature. And right now we're talking about the recall of, or the purported recall of a senator. I'm just wondering, if you were to expand the larger conversation, this has grave implications. How this is conducted has grave implications for our democracy. Do you agree?
Very strong, very strongly, very strongly. And it really makes me, and for every Nigerian, every Nigerian should be crying. I was just speaking with some people yesterday, and a military person told me that it's losing confidence in the system because we are not following our laws. We are not following the Constitution. We are not following mind, will, an arrangement, sentiment. So whatever I want to have right now must be based on who I know, what the person I know in power can give to me, not what the law says I can get. And that is what is playing out right now. And talking about the National Assembly, you could see one of the issues that came during the week was when they were talking about getting the approval from
the National Assembly for the state of emergency.
For the state of emergency.
In Rivers.
I expected that the National Assembly, like we have seen in the past, to have come up to say, no, we cannot get to this point because the reason for the state of emergency has not even arisen before it was declared. I felt very strongly that the president, who we have very strong respect for, as a Democrat, in short, I cannot put it within my head that the president himself can make such declaration with respect to Rivers State. Then the National Assembly, who should be a check in the normal democratic setting, like you see in other climes, the National Assembly is to put a check, is to say, oh, Mr. Executive, can you look at this? We need you to hold on and see whether it's, because I was just laughing when I saw the sole administrator appointing an SSG. Now, why I laughed when I was in the studio was because the background for Section 305 is that if you look at the first section, is you can declare a state of emergency when the federation is at war, or there's an actual breakdown of law and order, or likely a breakdown of law and order. You see, the real issue is breakdown of law and order. So the first person I expected him to appoint is to appoint security to go to the pipeline and protect it. It's not to appoint an SSG, because that we are doing is governance. The Constitution does not recognize the appointment of a sole administrator in the governance of a country when you have elected a governor. So the duty of a sole of state of emergency is to take, you look at the Constitution, it says to take an extraordinary measures in terms of security, measure to make sure that the state, that particular state, is secured. It could be as a result of flood, it could be as a result of disaster, but the extraordinary measure will be to address the issue of threat to life and property. But what we saw is the first appointment is to appoint an SSG, as if there's a problem in the government house. You want to start governance? No.
But isn't that
your
right?
measure should be to make sure that the state is secured. Expect him to see that he has sent people to the creeks to see why there is an explosion. No, he's not doing that. He's appointing an SSG. There is something fundamentally wrong with our system.
Yeah, but some people will argue, I mean, that the deployment of soldiers is not within the purview of a sole administrator. The soldiers only respond to their commander-in-chief, who is the president. And from what we understand, that was already done.
Who appointed the sole administrator? The administrator is an extension of the president because he was not elected. He couldn't have said he's representing Rivers people. So the sole administrator is an extension of the president. Because he was appointed to do what?
Yeah, but even then,
not to govern the state.
Yeah, but does his
take
powers,
extraordinary measure?
Yeah, does his powers then extend to appoint to deploying soldiers?
Because you are doing the bidding. The president appoints you. That's what I'm saying. He appointed you for something to forestall breakdown of law and order for security issues. And if you had that, that there were explosions and all of that. So that is the point I'm trying to make. That the intention of Section 305 is to address issue of breakdown of law and order. So the president's appointee, which in this case is the sole administrator, is to make sure that the state is secured. To make sure that those persons people who intended to cause breakdown of law and order, that they have been tamed. So I shouldn't be hearing SSG. No. You must keep the state safe. I expected the president should have told him, okay, the commander, GOC, be in the creek. That is what we'll be saying.
Yeah, but I mean,
that is the misplacement, and that is the abuse.
Not a justification. But what we heard also yesterday was that the head of service in Rivers State resigned. which of course, raises issues. Governance will still be going on in the middle of all that is happening, even security-wise in the state. If there are upheavals within the state civil service, wouldn't there be need to make sure that, whatever it is brought under control?
Good question. If the head of civil service resign, the most senior officer should take over. It happens. It's not within his purview to appoint. He's not elected. You have an elected. The governor was just suspended. I don't want to even. I saw a lot of media reports saying former governor. There's nothing like former governor Fubara. His tenure is for 4 years. So he was just suspended in the suppression. But just like state of emergency was declared by Jonathan during the time of insecurity. And it was to take if you look at the language, it's for extraordinary measures for security. So it is not within the purview of the sole administrator to appoint any person that has to do with governance. Because if he does, it means that was the intention. A man intended the consequence of his action. So it means that there was an intention to hijack and capture the governance of River State. And that is not the intention of Section 205. And that also faults the idea of suspension, of declaration of the suspension of the governor, his deputy, and the members of the State House of Assembly.
Let me bring the conversation back to the National Assembly, because you spoke about, what you expected of the National Assembly in that event. The National Assembly, at least in the House of Reps, in the Senate, we saw just how the debate went. Senator Seriake Dixon, raising an objection initially, and then much later we understand that I think about 3 senators or so walked out of that conversation to indicate their displeasure as to how the process was being handled, including Senator Tambuwal, who was there. In the House of Representatives, there was a correction or an amendment of some sort to what the president sought. The president, said that the Federal Executive Council was going to be making decisions for the governance in River State. And the House of Reps said, no, it is not within your purview. It is the House of Representatives that has the powers to do so in the event of breakdown of law and order, and the House of Assembly is unable to carry out its own constitutional duties. So do you think that in this instance, much as you might not agree about how the process was carried out in the House or the decision which they reached, do you think that they at least still stood up for something?
Yes, for the House of Representatives, that was good. And if you look at the declaration by the president, he also said that the Federal Executive Council will know. It is when there's a breakdown of law that such that the State House of Assembly cannot carry their function. The function of the State House of Assembly goes back to the National Assembly. So National Assembly start making laws for that particular state. So it is not in the Federal Executive Council. Now, so the House of Representatives, answering your question, they tried, but you see, there are something things that are fundamental. The issue of quorum, because that is a constitutional matter. You must establish first if there's a quorum, and not by saying that you have your register of members. No, you don't say you have a register of members. Anybody could have put his name and have gone out of the house, because you can indicate, you can come in, sign in your register and walk out. The quorum that is expected is the quorum of the persons inside the house. So the reference to, we are making use of the register, that itself is improper.
And it was after the vote was done. We had the speaker say, for the records, we have 243 members, who signed on this
based
register.
On the register.
Yes, but we also heard a member, who had taken objection, saying, Mr. Speaker, we need to take attendance of how many people are actually here.
Yeah, and that is you see, that is democracy. Why? It is because of what you want to approve. It's a constitutional matter. It is not a matter you should do a voice vote. You are going to be you are suspending elected persons. So it shouldn't be done with a kid's glove. So you must establish in the first place whether the total number of persons as required by the Constitution has been established before you proceed, because anything that is proceeded in error goes to no issue. But like you said, like we were discussing, we are not following, these are undemocratic democratic actions that we are seeing coming from the National Assembly. And I am praying and expecting that our leaders should conduct themselves in such a way that people on the street should have confidence in the system, because by the time the people start losing confidence in the system, it's going to increase the rate of crime in Nigeria, because crime always increases when people lost confidence in the system.
Okay, I'm just seeing this breaking news now coming in. Trying to confirm this. It says Justice Obiora Egwatu of the Federal High Court Abuja, who recently issued the controversial ex parte order against the Senate and its Ethics Committee in the case filed by suspended Senator Natasha Akpoti-Uduaghan, has officially recused himself from the matter today, March 25, 2025. We understand the case has now been adjourned sine die to allow the Chief Judge of the Federal High Court reassign it to a new judge. This is information that is just coming in, that Justice Egwatu of the Federal High Court, who recently issued the controversial, because they are saying this is controversial ex parte order against the Senate and its Ethics Committee in the case filed by suspended Senator Natasha Akpoti-Uduaghan, has officially recused himself from the matter today. So, I don't know, this is news, and this is just coming in. I do not know what you make of this.
Pressure. I mean, it's very simple as his lordship is under intense pressure.
Do you think that this is? Do you think this is controversial? Because there are people who have found it quite curious that Senator Natasha, went to court against the Senate Ethics Committee, seeking that they not take any action on certain things. She filed a petition to this same Senate Committee on Ethics with regards to a sexual harassment matter, but didn't take this same case to the court of law. Is there a reason for that?
Okay, because like you said, what she took to court was when she heard that she was going to be suspended. I was aware as one of her lawyers. I filed the first suit of defamation against the Senate President and his aide, So we didn't take the issue of sexual assault to the court because we know that she's going to present it before the floor, so that allegation is against the Senate President. So they are going to deal with it. And so she felt that she should present it before the House because it is affecting our legislative duty as a senator. So not just the criminal part of it under the various penal code, but she said no, she needs to let the House know so they can deal with it. Now, that issue was not in a court. We therefore expected that the Senate will just look into that issue.
Yeah, but the Senate also did say, I remember the first time when this matter was raised on the floor of the Senate, when she brought it up. I don't know whether it was one of the senators who said it was dead on arrival because
yes, the Shama Senate Committee.
She did not get the signature of
she signed by herself.
Yes, another senator was supposed to endorse it. I also heard the majority leader, Senator Kweyemi Bamidele, saying that the Senate could not look at that matter because the matter was in court, and that was because the Senate President's wife had taken the issue to court, given the allegation that she had already made on TV before bringing the petition to them. Do you think that could have put a hold or prevented the Senate Ethics Committee from looking at her petition?
The wife of the Senate President is not a member of the Senate.
Indeed, but the matter was, she took the matter to court.
No, what she took to court, I was served with the process.
Mm-hmm.
So what she took to court was defamation, not that act, that you defamed me by what you said against the Senate President, my husband. So the issue of defamation is one angle. They are going to look, does it amount to defamation? So the issue of, did he commit this offense, was anything like that, was not a subject that, should be talking about, that should be in court. So she just saying you defame. And if you look at it, of course, that is what the court will determine. She made an allegation against the Senate, the person of the Senate President. And I responded to that allegation that, look, madam, don't worry about your response. It is the business between the Senate President and Senator Natasha. So he has the capacity and the right to respond. So if he has anything against what Senator Natasha has said, he should be given the opportunity to respond. You should just hold on your peace. Let your husband respond. And that is what it should be. The allegation is made directly to the Senate president.
How confident was she that the Senate president was going to, I mean, that the Senate as a whole, given, just how a number of them already felt about this particular matter, was going to be able to carry out justice? Wouldn't it have been safer, to seek justice in the courts, given, some of the reactions of some of the members especially in the Senate already? I don't want to say the National Assembly.
Yeah, she maybe she believed that she will get justice from the senators, from the Senate. Reason being that some of the members, some of the senators are aware of what she was talking about.
The sexual harassment case.
No, they are aware of the fact that some of her rights have been deprived. But the reason for the alleged deprivation is what they don't know. So this was the first time she was saying that. And that was as a result of a protracted, altercation. She has had to present a bill for the Ajakuta, and the Senate president have told her that, you have to keep it on hold. She has approached the Senate president, and the Senate president just said, don't worry, said a lot of things. So she had confidence that the Senate were going to look at it, if not for what it's worth, just to give her the right of fair hearing. And what was expected was that the Senate president, since the allegation was against him, he was supposed to have stepped aside and let the deputy Senate president preside. But that was what she was expecting. But the anger was that was not done. Instead, she was being vilified. Instead, she was being shouted at as being, her conduct being, against the Senate rule and all of that. So that was the issue. And she was really confused that her fellow senators could not even give her the right of fair hearing, not to come talk about the rightness or wrongness of her allegation. So what she was confused about was that I should be given the right of fair hearing. You can conclude and say, it never happened, haven't investigated this matter. But you didn't give me the right to be heard. And that is the major issue. So you could as well have listened to her. She would have presented a complaint to the committee. The committee could have just come up to say, haven't investigated. We discovered that was not true. That could have been the end. Then she would not be left with whether to continue with it or to go to the court. But she was not given such opportunity. And that is the bane of the contention.
Well, we do know, as I did say earlier, that this matter is a developing story. I mean, with Justice Egwatu stepping down now, and this matter at John Sinadine, I don't know, there's nothing that can be done with it, is there?
I'm really surprised because that is the court that should have either declared the action of the Senate as unlawful and illegal. The court has now adjourned Sinadine, waiting for the Chief Judge of Federal High Court to assign. There's a process of recall. So you will just see that there is this, these manipulations coming from wherever Kota is coming from. Because so maybe somebody just wants, we want this process to go on. No, I think talking about democracy, I think people who go to court should be allowed, the court should be allowed to do their job. And whoever is aggrieved should be allowed to approach the court to express his grievances. And the court should take a position, whether or not that particular action is right or wrong. That should be the duty of the court. But people should not be muzzled. Like I always say, that the country will continue to die when the oppressed, the voice of the oppressed is removed from them. And that is the case of Natasha. We are saying that she felt oppressed. Let her be given the opportunity to express herself. Let her be given the opportunity to be heard. And whatever the result is an issue for another day.
We certainly will keep tabs with you on this. But excuse me, we have to thank you very much for coming on Sunrise Daily this morning.
Thank you for having
Mr. Victor Gewa is a legal practitioner and also one of the lawyers on the legal team of Senator Natasha Akpoti-Uduaghan. Well, as we leave the program this beautiful Tuesday morning, thank you so much for being a part of it. I'm Maokwe Ogun Yusuf.
Active day.